Ready?
I was born ready.
Welcome to Advisory Opinions. I'm Sarah Isgur, that's David French, and we are coming at you live from Catholic University, the law school here. David, it's a real treat. It's a snowy day. We made our way up here, though. Beautiful campus.
The memories. When I drive up to Catholic University, there was something that happened here, September of 2019. I had a little debate with Sorba Mari at Catholic University called the Melee at CUA. And I may have lost my temper in the debate, Sarah. So I have to come back and redeem myself by being relentlessly calm and kind, no matter how mean you are to me in the questions. But no, it's a real pleasure to be here. I love Catholic University, and it's a beautiful campus, beautiful place, and my entire experience is not the melee at CUA. I also have had other good experiences here.
Well, I hope some of the students take that as a challenge, so you can get under your skin. We have two guests with us today. Professor Joelle Alicea is the Associate Professor of Law and Director of the Center for Constitution and the Catholic Intellectual Tradition. And we have Judge Trevor McFadden. Judge McFadden is a judge on the DC court here. But more importantly, we work together at the Department of Justice. And more importantly than that, I knew his wife before I knew him. I knew when he was just a boyfriend.
That's right. Yeah. Might have known her longer than I've known her.
Ooh. Okay, we'll compare notes after.
You and I are having flashbacks to 8 years ago when we were spending a lot of time together.
One of the cool things about your background is also that you were a police officer after undergrad and before law school, which has to be pretty interesting as a judge. You've sort of been at the various steps. You haven't been a criminal defendant, but you've done everything else. What we're going to talk about today is the state of legal academia, the incentives in legal academia, how well it's serving law students, how well it's serving legal professionals who are actually going out and arguing in front of some of these judges and courts. And there's no one better to start with than you, Professor Alicea. You, in fact, have your students here. It was the first day of your con law class.
That's right.
And I asked you what you started with, and I actually think it's worth rehash a little con law 1L year for us here it's also the Columbus School of Law. Is that Christopher Columbus?
That's right. Yes.
Okay, so the uncanceled Christopher Columbus here. Okay.
He will never be canceled here.
Little side note, I really liked that once Christopher Columbus has been canceled, then they discovered he was a Jew. And I was like, that figures. That feels so right. But here he is still Catholic at the Columbus School of Law, Catholic University. And you started con law for your 1Ls. And in my con law class, we went to the same...
got awkward.
No, it's good. If you don't believe in Jewish Christopher Columbus, I don't know what we're doing. We went to the same law school. And so in theory, con law was not required at our law school.
That's right.
And is it not required?
Not while we were there. I think it now is, but it was not while we were there.
Wow. And in fact, when I took con law, it was famously, the Constitution was Appendix B. Not even A, y'all. B. So, how's your class going?
So it's not Appendix B. We start this semester, I'm teaching constitutional law, structure, separation of powers, and federalism to 1Ls this semester. Many of them are in the room today. I just walked over here from the first day of class, and I usually start Con Law 1, especially by doing a kind of an overview of the whole Constitution, just walking through every provision of the unamended Constitution to give a sense of what each provision is about, very briefly, obviously, but also to give them a roadmap of what we're going to be covering moving forward throughout the rest of the semester. And I think it's important for students to read through the whole Constitution at some point and to get some sense of what each provision is about. But that was not my original idea. That was an idea that I picked up from my teacher, Justice Kavanaugh, who taught me separation of powers at Harvard Law School for a semester. And that's what he did. He started with a guided tour of the Constitution on the first day of class. And I was so struck by that and thought that it was such a good idea that I implemented it myself.
But I feel like this is going to weird out listeners who are like, but how else would you do it? I mean, we have right now, even set aside how you might have done it 50 years ago. Right now, the Supreme Court is interested in the text, the history, let's throw in tradition and precedent kind of in that third bucket together. So like, of course, you'd be reading the text of the Constitution and right, you would probably want to go into the history of how you got to those words, right? They didn't come out of nowhere. James Madison wasn't that original. So it might confuse them to why what you're saying is special.
Well, I think that in a lot of constitutional law courses, the text plays very little role in the instruction of constitutional law. And that's because so much of current Supreme Court doctrine departs from the text in significant ways, or doesn't engage with the text in an extensive way in the opinions themselves. And because a lot of professors want to teach current doctrine, as I do as well, obviously, the text kind of recedes into the background. But I think it's important to bring the text into the foreground as we're talking about these cases, so that you're not just learning current doctrine, but you're also learning how has current doctrine potentially departed from the text, how might it realign with the text by this court in future years, so that you know where doctrine might be moving and not just where it is currently.
Yeah, so maybe current law schools tend to do precedent history text.
Right. I think that's basically right. Yeah.
So I think I'm the oldest person here on the panel by a month or two. But I'm very curious, Judge. How were you taught constitutional law, and what presence did originalism have in that instruction? Because I was taught constitutional law in 1992, and there was not much about originalism at all. I had an outstanding teacher, but it was nowhere near the dominant strain of legal philosophy. And it was definitely on the outer edges, definitely. And it was taught as being on the outer edges.
Yeah, no, I agree. And thanks so much to both of you for having me, and to Catholic for hosting this event. I went to University of Virginia, and I'm proud to say con law was required, but it was not an originalist class by any means. We did have some great originalist faculty on staff, but my professor, she was terrific, and I think she did a nice job of trying to tease out different sides of an issue, but it was not based on the text. You kind of go through the seminal cases, and my main recollection from con law is my one conservative friend and I like looking at each other across the big seminar room, and I could just kind of see him getting angrier and angrier, like, here it comes, and then there'd be some question like, this is preposterous, how can you do this? And everybody else would be like, so yes, it was not a Professor Alicea class, I'm sure.
You know, when I was taught it, I was taught originalism in the same way that I was taught growing up in a very fundamentalist Protestant sect in the South, the way I was taught about Catholicism. Which, hang with me.
You thought my Jewish Columbus thing was awkward?
I know. It's about to get a lot more awkward. But you know, when you grow up in a very strict religious community, the way you are often taught about other points of view is all the ways they're wrong. Right? So it's not that you're taught about them, you're taught against them, if that makes sense. And so what you learn about it is very partial. It's very fragmented. It's incomplete. And that's how I would say I was taught about originalism in law school. I wasn't taught about it, I was taught against it.
Yeah. And I think that's probably still true at a lot of law schools where, you know, maybe we can be thankful that originalism is even mentioned, but it certainly is not taught by scholars like Professor Alicea and other scholars you see at Notre Dame, at Scalia Law, who understand it, who've been making these types of arguments and research themselves.
But it's kind of weird. I mean, we listen to a lot of Supreme Court oral arguments, and we comment frequently that I think it's odd that when you have 5 originalists on the court and a 6th conservative member of the court, that you would ever send someone to argue your point of view who is not fluent in originalism or text history and tradition, and yet it seems to happen every single day, and I remain baffled. And at least as a second language or something. And I'm curious, just from their own incentive structure, why you think that's not happening?
Well, I think that especially at the top schools, they feel somewhat immune from the potential ramifications of their students going forward without that kind of preparation, because they feel like they're going to get a lot of great students no matter what they do and how ill-served their students are by their method of instruction. But at a school where you really do care about instructing your students well and preparing them effectively for life in legal practice, it's essential for them to understand how to make arguments in an originalist mode, even if they're not originalists, right? In some ways, especially if they're not originalists, because it might be a foreign way of thinking for them. So it's even more important for them to learn it. Again, even if that's not to say that they need to be originalists or that they agree with these types of outcomes, but if you're going to be an effective advocate, you need to know how to speak to an audience that is composed of judges that are predominantly originalists or at least very sympathetic to originalism. And that's why I spend a lot of time on the history of these provisions in my common law courses and try to integrate some originalist theory into the courses for my students to just be familiar with that, not at all to push originalism on them, but for them to be effective advocates later on.
Judge, how much are you doing remedial education for your clerks when they show up? Because now that we're in the era of multiple clerkships, I'm also curious how many are coming from circuit courts to you versus going to circuit courts, and how you're and the clerkships are supposed to be a fourth year of law school, or fifth or sixth as it's turning into.
Yeah. So I've got my 3 clerks with me today. All of them are coming from circuit clerkships. And I think we're really privileged in the DC district courts. The caliber of clerks that we're getting, has been a long time since I have hired anybody who was not much smarter than I am. Thankfully, the remedial issue is not a problem for me, but a lot of that is because of very intentional screening, looking for students who've come from law schools where originalism is not considered a dirty word, looking at the types of extra curricular activities that they've done, things like Georgetown does an originalism boot camp, the Heritage Foundation does a clerkship academy. There are the Blackstone Fellowship. There are ways that people can help prepare themselves, even if they're being ill-served by their law schools. And that's really important, because certainly, as you point out, Sarah, to be an effective Supreme Court advocate, surely you've got to be conversant with originalism. But it's not just in the Supreme Court. It's, I think, one of the most interesting areas of the law right now is Second Amendment jurisprudence. And that's being dealt with in trial courts all over the country. And so, how can you be a good public defender? How can you be a good prosecutor? How can you be a good district court law clerk if you don't have some basic understanding of this cutting edge area?
We have spent many frustrating hours and advisory opinions talking about the state of Second Amendment jurisprudence, and we're just podcasting. I can only imagine sorting that through, and we have expressed sympathy for circuit and district court judges sorting through the Second Amendment right now. But one of the things that I think is interesting, that I think is a pitch to make to law students who might be very much not originalists themselves, maybe very frustrated with an originalist court, is that to remind them that if you can speak it fluently, you can actually win. You can actually persuade. And when I think about this, I think about the Bostock case, because I believe it's David Cole from the ACLU argued that. Forgive me if I'm wrong. I'm pretty sure it's David Cole. But he walked into that argument speaking fluent originalist. And as if he had an audience of one, Justice Gorsuch. It felt like he was walking in speaking fluent Gorsuch. And I feel as if too many people, when they think through originalism, they think of it as a foregone conclusion what originalism means, versus, no, it's the beginning of a debate, but it's a debate conducted within certain parameters versus a discussion entirely of outcomes.
Yeah, I think we've seen that in some of the very interesting separate opinions from Justices Barrett and Kavanaugh, for example, in the Rahimi case, a Second Amendment case, so going back to Second Amendment and its unsettled nature, you see real disagreements there about the implications of a historical-based methodology for how to think about the Second Amendment. And some of those disagreements are principled disagreements, not just contingent ones. And so I think you're right, David, that it's a mistake to think of originalism as monolithic or as only leading to politically conservative outcomes when applied faithfully. Justice Scalia famously, wrote several opinions that sided with criminal defendants in ways that were contrary to his political preferences, but that he thought were just required by an originalist methodology.
Okay. On the flip side, our current Federalist Society students who are immersed in text history and tradition and originalism, what are they missing out on? What's the next thing? What's the next language that students need to be fluent in? Maybe on the left, maybe from somewhere else. And is that, are law schools such a lagging indicator on where the legal profession is and actual law? That this is sort of, by the time we're teaching them originalism, the world will have moved on to something else anyway?
I'm skeptical that that's going to happen. I think originalism, frankly, has been with us since the founding, and we just forgot about it for a few decades along the way.
Like 15 of them.
15, we're just becoming an old country at this point. I think you raise an important point, Sarah, in that what my pitch to law students, to law schools, frankly, would be for a diversity of viewpoints. That you're certainly, I'm looking to hire future litigators, and they cannot be assured of litigating in front of an originalist judge. And even if you have an originalist judge, she may well be bound by very non-originalist precedent. And so I don't think there's the suggestion here that it's originalism or nothing. I think well-trained attorneys need to be able to make the best arguments for their clients. And that may be an originalist argument. Perhaps it's not. In terms of what's cutting edge, I mean, it's something that I've been learning a lot about recently is corpus linguistics.
I knew you were going to say corpus linguistics. Anytime you hear a judge say, something I've been learning a lot about, it always ends in corpus linguistics.
It certainly does not mean I mastered it, but
Explain to these 1Ls here what corpus linguistics is.
We're so cutting edge. We've had a whole podcast about corpus linguistics. Yeah.
Go listen to the podcast. But I would, my nutshell would be, it's almost like a LexisNexis for a certain era of texts. And so you have these databases that will pull up original sources from whatever time period you're looking for. And so if you're doing, Second Amendment arguments, you can go back and look at how these terms, keep and bear arms, would have been used in newspapers, in statutes, in cases, but around that time, to help you understand how these terms would have been used. But
side note, isn't it odd that any part of originalism would require modern technology to do it?
It certainly makes it easier.
You can't do good originalism without AI.
Right.
Okay.
That's weird.
But corpus linguistics is not just an originalist. The cases I've used it on have both been, one was a statute and one was a sentencing guideline. And so, using, looking to how certain terms were used at the time those terms were put into the governing text helps elucidate the meaning.
So you mentioned a point that I think is really, it's always been very interesting to me about the legal academy, and that is viewpoint diversity or ideological diversity, however you want to phrase it. It seemed to me that if you're going to look at the legal academy versus, say, the humanities in elite education, the legal academy always did a little bit better on having different voices in the faculty, but only a little bit better. There was always a very dominant strain. I remember I was speaking about this issue several years ago to a group of students at University of Kentucky Law School, actually. And I was talking about, well, the legal academy does better than the humanities, but it still has a lot of work to do. And a professor at the school got very angry and was saying the legal academy is quite diverse. And he named all 4 of the conservative professors that he could think of at Harvard and Yale. And I was thinking, if you can name them all off the top of your head, that's not all, you're kind of making my point, right? But I feel like things in the sense is that the legal academy seems more open maybe than some of the humanities, but what do you see as the state of openness to diverse points of view?
I do think that there is more openness in the legal academy than in a lot of the Faculty of Arts and Sciences across the country to viewpoint diversity. And I think that that's because there is still an orientation towards argument and debate in law school just by nature of the profession, right? And so it would be very strange if law schools just had a complete absence of contrary viewpoints. That being said, they're not doing great,
right?
Like it's still the case that the number of originalists or politically conservative law professors at the very top law schools is a very small number, right? Again, you can probably name them all fairly easily, at least the ones that are out and not just kind of quiet about it. And I think that is a real problem, because not only because it disturbs those students are not going to be exposed to the best arguments on all sides of a given issue, especially the students who agree with their faculty on the left of those faculties. Those students in particular will not get exposure to contrary viewpoints, and that will inhibit their ability in legal practice to be effective advocates or to go out and just be better citizens in understanding different viewpoints. But it also creates this problem where those schools then feed into the most elite parts of our society. And so those people who themselves don't have a good appreciation for different viewpoints become culture formers and culture makers that reinforce that kind of obliviousness. And that's really destructive, I think, which makes it important, therefore, to have schools like this one, like Catholic University's Law School, where we do have a broad range of different viewpoints represented on the faculty, and where you have all within the ambit of the Catholic mission, but different viewpoints that teach our students different points of view and allow them to be better trained for legal practice.
There also seems to be a real issue, though, of conservatives not wanting to go into academia potentially. And I know there's some chicken and egg, right? If you don't feel welcome, if you don't think you're going to get the job, then you don't apply for the job. But also there was sort of, at least in my time in law school, this stereotype that the liberals were interested in sort of more the low-paid public service and the conservatives were going to go make money. So yeah, they weren't going into academia. They're not thinking thoughts. They're going to go, represent Exxon and club some baby seals. God damn it.
Yeah.
So I think that is just a really lame excuse. Like it's the kind of excuse you can tell yourself if you already have a very low opinion of the people with whom you disagree. Because you can just kind of dismiss them as not particularly intellectually sophisticated. And I think that the reality is that there are a lot of conservatives who have the credentials and the capability to be great legal scholars who never seriously consider a career in academia because they are just relentlessly sent the message throughout their educational formation that this is not a career for you. Because if you try to go into legal academia, you will face unrelenting hostility. And that kind of message does filter down. So I have so many conversations with so many law students and young lawyers who are interested in academia and in scholarship, where the most of the conversation is just like, is this even really plausible for me because of the barriers I would face as a conservative? And that is just not a conversation that has to happen on the other side. Right. On the other side, the barriers to entry to academia are very high for anyone, right? It's a very hard job to get, no matter what your viewpoint is. But they do not, those on the left side of the spectrum just don't have to have those types of conversations about, gosh, what kind of hostility am I going to face, both in getting into the academy, but also if I'm lucky enough to get into the academy, from my colleagues and even potentially from my students, right? And that is something that really does deter a lot of people from going in.
The dynamic, I was looking into some of these numbers after, was it Judge Duncan at Stanford who was shouted down? So I was looking at some of the numbers, and it was saying that the legal profession is to the left of the general public, just by a bit. I mean, the median lawyer is to the left of the just median non-lawyer American. The legal academy at writ large is to the left of the legal profession. Elite law students at quote elite schools are to the left of the legal academy. And then the faculty at the quote elite law schools are to the left of the law students at those schools. And so it just keeps moving more left in sort of your median political view, the more that a school climbs up the rankings. That is kind of mirroring much of the rest of education in the United States. We're now reaching a point where you cannot talk about the college experience as one thing ideologically. If you go to Princeton and you go to Chicago, they're going to be different experiences now. If you go to Columbia or you go to Vanderbilt, very different. And that's not even including your SEC schools, which are going to have, again, very, very different, or your CCCU schools, that's the Council for Christian Colleges and Universities. Is the legal academy diversifying to the same extent? And maybe this is a good opportunity to talk about some of the things that Catholic has been doing to distinguish itself. But my sense is that the legal academy is also diversifying itself a bit. It's not one big blob as much anymore.
Yeah, I think that's true. I think that there are two kind of tracks to think about. There's the extent to which dominant current institutions that have traditionally been predominantly been served by the left, like Harvard and Yale, Stanford, places like that, the extent to which they hire people with different viewpoints, especially conservatives. And then there's the other question about, well, what about alternative institutions that build up little enclaves for those who are not part of this dominant view within the legal academy? And the latter is really an example of Notre Dame and George Mason and here, Catholic University, which doesn't mean that those schools only have conservatives or those schools only have originalists. It's just that they are actually more faithful to the true purpose of a university and a law school, which is to recruit people who are the best and who are pursuing the truth honestly, and to expose their students to the diverse range of viewpoints to better equip them for legal practice. And that is actually what all these law schools should be doing. Obviously, Catholic University and Notre Dame have a different component in that we have an explicit Catholic mission, right? And that also affects the kind of community that we're building here. But it does mean that our students get exposure to faculty and to resources that they would not get at a lot of other institutions. And I think in that way are better equipped to go out into legal practice than they would be if they graduated completely oblivious to contrary viewpoints from a lot of other places.
All right, Judge, let's talk law school incentives. You have the U.S. News and World Report rankings. It seems to dominate academia, not just law school academia, but we talk about the T14. They're the only game in town. The T14 refers to the U.S. News and World Report's determination of what the top 14 schools are and why it ended up being 14 that we care about instead of any round number. I have no idea of the history of that. Maybe you do. And so what we've also done then, we've talked about viewpoint diversity, but I want to talk about a different type of diversity, which is just experimental educational diversity, diversity in terms of what you're focusing on. Because if everything is based on U.S. News and World Report and they value X, Y, and Z, the schools are all going to chase X, Y, and Z, right? What's the law that once a measure turns into a metric, it ceases to be a valuable measure anymore? I feel like we must be there and way past there when it comes to legal academia. And so we're basically churning out the same law schools over and over again because of those metrics. And indeed, we've had some, at least one, I'm thinking of, criminal indictment related to trying to game the system and lie about, law schools. I think that was undergrad. I think it was Columbia.
I'm surprised.
So how does that affect legal academia, and what are we supposed to do about it when the money follows U.S. News and World Report because the students follow U.S. News and World Report, et cetera?
I mean, there was a report that a trustee at the University of Florida burst into tears at the decline of Florida's ranking under Ben Sass, like the U.S. News ranking. Like, you've got trustees bawling about this. So how to break out of this prison, Judge?
I guess as a consumer of law school's production, that is law students, I certainly am you're aware of the rankings, but I don't think that is the be all and the end all.
Okay, where did your 3 law clerks go to school? Let's test this.
Oh dear.
You're not going to spout platitudes to me.
UVA, Yale, and Cornell.
Oh, interesting that those are all in the T14.
Sir, that's true.
Cornell's, no.
Last year, I had a law student from Notre Dame. I do, one of the things that Justice Thomas is kind of famous for is looking quite broadly and bringing in top law students from whatever the law school is. And
of course, in the reverse, Justice Scalia had the famous line, the schools may not turn a sow's ear into a silk purse, but those top schools are unlikely to turn a silk purse into a sow's ear, so I don't bother to look anywhere else. Like, they're taking the silk purses, right? So like, there might be silk purses elsewhere, but I know these are silk purses, and so that was his excuse.
Yeah, and I'm a huge admirer of both of those justices. I would say when you look at what justices' law clerks have gone on to make a difference in the country, I would have a hard time thinking of any justice whose law clerks have not gone on to become judges and law professors and just speak into the public sphere the way that Justice Thomas's clerks have done. There's probably a number of reasons for that, but I think one is his very intentional attempt to go away from just kind of the quarters of power. I think there are things that it's not just judges, but alumni can do, citizens can do. If you want to see your law school putting out law students who are able to work in a variety of situations and respond to a variety of justices, you should be looking for viewpoint diversity. And Judge Thapar spoke on some of these things in his Joseph Story lecture this last fall, but write to your dean, say, I love contributing to my law school, but I'd like to make sure that the law school is not missing this opportunity to put out litigators who can properly address the current Supreme Court. Most of us have our taxpayers in a state that funds one or more law schools. Is your law school, the state law school, is there viewpoint diversity there? If not, maybe that's something that you should be writing to your state senator or your governor about.
What about boycotts from the judges?
So I am not boycotting any law school. Obviously, I've got a Yale law grad with me today.
We all assume Yale would definitely be boycotted.
That's the one.
I'm a huge fan of Judges Ho and Judges Branch, and I think, frankly, the attention that they brought to bear on this issue has probably been really helpful. Yale has hired an Alito clerk just within the last year, Professor West, Keith Whittington. I think I'm optimistic that law schools, even in the T14, and perhaps especially in the T14, are recognizing that they may be out of step with where the rest of the country and the courts are, and I'm looking to provide some of that viewpoint diversity.
I think that's really important, but it's also important for schools that are already homes to a broader range of viewpoints to themselves just become top-ranked schools, right? Not to just wait to see if Harvard and Yale can become more intellectually diverse. But I think it's very encouraging, right, that Notre Dame is a top 20, top 25 law school in the current rankings, that George Mason is top 30, top 35. We here at Catholic University jumped, I think, 28 spots last year. We're projected to jump another 20 spots this year. We're moving up very rapidly and attracting the kind of high-quality faculty and students as a result. So we just got Jen Mascott, who came over from George Mason.
Thomas Clerk.
And Mark DiGirolamo came over from St. John's, Kevin Walsh from Richmond. So these are high-quality scholars that we've attracted because of this effort to create a community that is welcoming to scholars who are excluded from a lot of the rest of the academy, or at least don't face the same kind of cultural environment that they would have here, which again, I want to emphasize does not mean creating a monolithically conservative or originalist school. It just means creating a law school that is actually true to the purpose of law schools, one that actually is open to viewpoints that much of the rest of the academy does not take seriously.
So shifting gears a little bit from sort of the ideological viewpoints to just the practice of law itself, how are law schools doing now in actually preparing people to practice law? That was the one thing I will say. I loved my 3 years in law school. I had a great time. I did not learn how to practice law. Most of my teachers were critical legal theorists. So I had a lot of critical legal theory. I had very little originalism. So when I started practice, I was handed a file and told to draft a complaint. You might as well have asked me to construct the space shuttle for all I knew how to draft that complaint. I could have absolutely heard the fact pattern and tell you how it oppressed historically marginalized peoples, but I could not draft a complaint. And so where are we on teaching students to actually practice?
And should we be?
Yeah, that's a great, I guess I'm presuming that we should. Should we be?
So again, as a consumer of law school products, I absolutely hope that law schools are preparing their students to be lawyers, to be litigators. I'll tell you a positive note that I think might have be different or more common since you went to law school, David, and I wonder what Professor Alicea would say about where we are now. I think clinics are a great opportunity, something that I really encourage law students to consider, especially in your 3L year. I did a prosecution clinic, worked in a little Commonwealth Attorney's office in the middle of Virginia, and I got to handle a number of trials, including a few jury trials, as a third year, using my third year practice certificate, and so that gave me a lot of experience and confidence and excitement about going on to become a prosecutor. So I think, and of course there are Supreme Court clinics, there's defense clinics. There's a number of ways that I think law schools look to get their students out into actually practicing law, and I'm a huge fan of that. Internships are another great opportunity, and especially for law students who might find themselves at a law school that doesn't have a lot of originalist scholars. Interning for a judge or in an organization where you might be able to get some of that experience and opportunity to see originalist arguments considered, I think is a real help.
I won't say that I had no clinical. I did do a clinical with the U.S. Attorney's Office in the Eastern District of Massachusetts, but they had me answering prisoner petitions. And one of them was a lawsuit against Satan and the United States government, suing.
Represent.
No, I was representing the government. Yeah. I mean, Satan's co-counsel was pretty interesting, but literally suing Satan for making him commit the crime and suing the U.S. for prosecuting him for a crime that Satan made him commit. But that made me learn about, this was a very useful thing from law school, there's actually precedent. Did y'all know this? About lawsuits against Satan? United States ex rel Mayo v. Satan and his staff. Yes, it's a 1971 case.
I can't believe I actually did read that in law school.
Did you read that in law school?
So I thought you were going to say you worked on that case and my job was about to drop, but then I saw it was 1971.
And you were about to make another thing.
I was.
That was way too late for me. Yeah.
After your time.
But that was, I relied on sorry for the diversion, but.
Okay, I want to push back on the idea that law school is supposed to teach you how to be an actual litigator for a couple of reasons. One, I love the clinics, and I think doing that, especially 3L year, is super great. And because it lets you try different hats on to see, like, well, I thought I'd want to be a prosecutor based on no information except law and order, and now maybe I do, maybe I don't. But I actually think spending 2 years learning about the theory of the law, why we practice the law, A, is good. And B, of course, I actually feel like law school can be a bit of a conveyor belt. Like you get on the conveyor belt and it drops you off at White and Case or something at the end. I felt like nobody told me. I mean, I went into law school having watched all of the Law and Orders. Full disclosure. That is what I knew about law school. I went and visited Justice Holmes's grave in Arlington Cemetery and I was like, check, I'm ready for law school. I didn't know about transactional stuff. I still don't actually. No clue what they're doing out there. Of my four, there was like a group of four of us in our 1L section, 2 went on to transactional stuff. I do not know what they do. They've tried to explain it to me and I'm still quite lost. So having 2 years where we don't tell people you need to already know what you're doing, we need to draft a complaint, all of that, I think is good, or at least should be pushed back on that it's not good.
I guess I would say that I don't think these have to be mutually exclusive. So I teach civil procedure, for example, in addition to con law here at CUA. And when I teach civil procedure, in addition to covering Iqbal and Twombly and getting my students to understand the theory behind pleading standards, I also have them draft a complaint, and I also have them evaluate, a 12b6 motion, one that actually exists, so that they can read it and see what this looks like. And I think that you don't want to just, as you said, you don't want to look at law school as just a way to teach you how to write a complaint, but you also don't want to ignore that skill set in teaching the theory. You want to integrate theory and skills together. And I think that is something that schools like ours do really well, but that a lot of top schools don't do as well because they tend to only emphasize theory. I just don't see why that has to be the case, why you have to choose one or the other.
By the way, I am having this wonderful moment flashback. So Joel and I did not overlap in law school, but he followed me as Federalist Society president after I was gone. And I remember the day you became Federalist Society president. And here you are, all grown up teaching your own law students. And it's so crazy.
Sarah can get you on the older and the younger age thing. She can get you both directions.
We have this, it's now a 25-year-old email chain. And as you become Harvard FedSoc president, you get added to this email chain, and all the old presidents give you grief and threaten you. And I remember threatening you, and it's a fond memory.
Yeah. Yeah, no, and that support was really invaluable at the time. That support.
I think it was don't mess it up. Okay, any last minute big picture thoughts on the state of legal academia from either of you guys before we do Q&A?
Along the lines of things that law students can do if you find yourself at a law school that does not properly reflect the viewpoint diversity of the current legal community, you can do something about it. I'm not the only consumer of law school. You are as well. And go meet with your dean, meet with the hiring chair. I mean, if law school hired 10 white men for faculty positions in a row, you can be assured there would be appropriate concerns from affinity groups, from law students, from alumni, wanting to meet with the law school dean, wanting to meet with the academic chair. You are in a similar position if you are being denied the diversity of legal viewpoints that are reflected in the broader legal community.
That's a great point. Yeah.
All right, we have a microphone to pass around. And just to be clear, while someone's raising their hand out there, your question does not need to be related to anything we talked about today. So if you've got a Judge McFadden question on any of the interesting cases or how he met his wife, that's fair game. What we said about him.
From Sarah, though.
Yeah. What we said about him when she first mentioned him. We're I don't know.
Hi, I'm a fan of your podcast as it is, so it's very cool that you're here. My question is, how do classic legal conservatives, fusionists, originalists, defend our institutions like the Federalist Society from what seems to be new fads on the American legal right that seem only concerned with power? I think of what Senator Hawley said after Bostock was handed down, when he questioned whether it was originalism was, still useful or worth it anymore. How do we go about defending our traditional legal philosophies?
I'm going to let them answer that, but I do have two notes. One, it's one of my favorite lines, right? He says, if this is what we've been fighting for with originalism, we haven't been fighting for very much. I don't mean favorite that I agree with it. I mean, it's such a perfect encapsulation of that viewpoint. Second, you said that David Cole argued that case. It was actually Pam Carlin from Stanford.
Oh, Bostock.
Yeah.
Okay.
Just noting. Fact checking in real time. Okay, I'm out.
So I think the way to push back is just to reintroduce the foundational principles and explain them in a way that is accessible and potentially acceptable to those who are criticizing them on the right. So, for example, you've seen some of the move in kind of the vein of your question from a lot of social conservatives and especially a lot of Catholics, actually, after Bostock, criticizing originalism and textualism from a natural law point of view. And my own scholarship responds to that, and the scholarship of some of my colleagues here, like Kevin Walsh, responding to that by re-explaining originalism and grounding it in a natural law perspective. And I think that's important to do, to not just dismiss those critics, to not just say, well, they're just they're only results oriented or something like that. They often have legitimate criticisms that are motivating part of their unhappiness. And you want to address those criticisms as close to on their own terms as you can, and not just kind of marginalize them. So I think that has led to a fruitful debate within the conservative legal movement over the last few years on the natural law side of things about the relationship between originalism and natural law.
I also think that in some ways the force of the critique of originalism has been blunted since Dobbs. So if you go to Bostock was before Dobbs, and the argument in Bostock was, wait, if originalism can lead a Justice Gorsuch or Justice Roberts to essentially, in the view of critics, change the meaning of Title VII, then what is originalism? Originalism is just as malleable as anything else. And then the other thought was, well, originalism is so process-oriented, it doesn't ultimately yield any outcomes worth talking about. And then the Dobbs decision happens, which was a very originalist opinion. And so sort of this idea that classical liberalism and originalism sort of as a judicial philosophy is not going to yield any sort of substantial change was just detonated with that decision. And so I have seen a lot less force from sort of what you might call the more authoritarian or common good constitutionalism. Their arguments have a lot less force post-Dobbs. But also one of the things that's giving the arguments less force is the reality that, as the professor said, look, there are legitimate criticisms that have yielded some of this legal thought. Absolutely, no question. But then what ends up happening is, this is what happens in the marketplace of ideas, is you bring out new ideas. One thing the Federalist Society is really good about doing traditionally is trotting them out all over the country for debate. And in a lot of the debates, it hasn't fared well, quite frankly, because when you start to really press, once you get past I'm dissatisfied with outcome A, B, and C, once you sort of get past that critique, then what you replace it with, that's where the critique, that's where the case really starts to show its strains and its cracks. Because at the end of the day, a process does matter. Processes do matter. And while a lot of folks on the new right scorn procedural liberalism, you can never get away from process. It exists, it matters. And that's where a lot of sort of the new right critique, I think, has the strains in the argument have really been exposed through a lot of public debate.
As a historical matter, I just find it fascinating. The Federalist Society and the world of originalism really came as a response to the Warren Court. If the argument is the Warren Court was sort of the Platonic guardians, this idea that we just appoint 9 people and we hope they're smart and make some good decisions for us all, and they take things out of the political arena because they know better what it should be, so don't leave these things to the majority. what would have made the most sense in, roughly 1978 to 1985 at that point was to simply have different platonic guardians from the right. And as Reagan's coming into office and Meese is Attorney General, it is a shocking point of history that that's not the way they respond, that instead they respond with process. That's my positive thing to say about it. My negative thing to say about it, though, is that now, 50 years later, you're at the hard part of originalism. This is the edge cases. The easy stuff has all been sorted out. Like, Justice Scalia got the low-hanging fruit. How much fun for him. Now you've got to climb to the top of that tree, Justices Barrett and Kavanaugh and Gorsuch, for the next 30 years. Good luck. And I think that's going to be open to a lot of criticism because you reach, in some ways, the end of originalism. Like, there's no right answer.
The Second Amendment context. What's the original public meaning of the Second Amendment as it pertains to a 30-round magazine?
Thank you, Judge.
Or is Satan one of the parties?
Satan's a party there. But by the way, I just want to say I'm not hallucinating and everybody gets their due. David Cole did argue the funeral home trans part of it was the...
You're right. It was...
Yeah. So everybody gets their due now.
Okay. I fact-checked David, and he fact-checked me right back.
That's how it works.
Welcome to Advisory Opinions. Normally, this is handled in the editing process. All right. Another question. There was another hand back there. And Judge, no matter what this question is, it's to you. So let's just Russian roulette this.
That's great. So I am a law student at a T90 school. It's this one. Yes, Professor. Well, how far can I realistically go, and how do I get there?
You mean in career-wise?
Absolutely.
Yeah. I don't think you are going to be held back one bit by coming out of Catholic. I think you might have to work harder. There are probably networks that Sarah had coming out of HLS that some of the rest of us did not have.
Your wife.
Wow, that was almost your mama. But I mean, if you look at the lawyers at the top of the administration, both the outgoing one or incoming one, if you look at lawyers who are really making their marks in the marketplace, they are talented people who work hard. And I think that where your diploma is from, will never matter more than it matters your first job out of law school. After that, you're looking at, any employer is looking at, well, how did he do at his last job, and what does his boss say about him, and do people like him? And so those types of factors, this is a building block, and of course law school is a very important building block, but a lot of it is part of the point I think we've been trying to make here today is that as much as the name on the diploma, it's what are the building blocks that you are acquiring in law school. And if you're at a school that's going to give you the ability to make arguments, successful arguments for your client, you're getting a good education. And that is by no means encapsulated in the U.S. News and World Report rankings.
I would say nothing, and there's no such thing as a perfect meritocracy, but as a general matter, good lawyers tend to do well in the United States of America. And one of the most perspective altering experiences that I had was leaving Harvard Law School and then going and practicing law in Kentucky. I was, in almost every case, I was the only Harvard lawyer in the cases. And there were times, guys, especially early in my career, when I was just brutalized in court. Like, it was ugly. They were better than me. They were just better lawyers than me, especially at that stage in my career. And it showed in outcomes. It showed in their success. And, one of the things that I have told young lawyers is if you have the skill set and you work hard and you have an opportunity, and you will get an opportunity, you really have tremendous potential. just tremendous potential. There's just no question about it. And I would echo what the judge said. There are some doors that swing open more easily depending on the ranking of the school. But a human being still has to walk through that door and perform. I will never forget sitting down. I was co-counsel in a case in Kentucky in a rural courthouse. And I was younger, he was older. And I was basically just helping him research and things like that. He was arguing the case. He was brilliant. And he demolished a legal team. I can't remember the firm, Skadden somewhere. It's a top team. Top firm. And I'll never forget sitting with him in this bar after, and he's got that Kentucky accent, and he just takes a sip of his beer and he goes, "That old boy from New York thought I was dumb because I talk funny." It was a great lesson. Credentials are nice. Performance matters, and you're going to have an opportunity to perform. Just know that, understand that. You're going to have an opportunity to perform, and you're going to be able to do it. And that's one thing I actually like about the legal profession. Sarah and I have this long-running fight over should you go to law school or not.
You guys have already failed my test.
You're all here. Congratulations, I won. But I think it's just a tremendous profession. I mean, a tremendous education that puts you on a path, whether it's in law or not, to where it's hard to see ceilings. It's hard to see where is my hard and fast ceiling. You're going to absolutely have an opportunity to perform, and you should not feel limited in any way.
All right, last question. Okay, yeah.
Hi, my name's Christopher Dodd, no relation to the senator. My question is for all y'all, and it has to do with kind of the ideological diversity that's been discussed here. So what can we as law students do to expose ourselves to those diverse viewpoints that we've been discussing this entire time? And I guess that applies for schools that have more ideological diversity like Catholic, but then also at those other institutions which are perhaps more of an ideological monolith.
Well, I think that there are some models already out there. For example, I know at Yale Law School, the Federal Society chapter there organizes reading groups to go through scholarship on originalism or textualism and kind of teach themselves and expose themselves to this range of views that they're not necessarily getting in the classroom. That's a great entrepreneurial thing to do, right? If you're at a law school where you feel like you're not getting what you need, try to assemble your own syllabus of readings and get some other students to go through them with you. I think at Yale, they actually get credit for it, which is even better. But if you don't get credit, that's fine. It's still worth doing on your own. I think that technology can really help here, where you can form networks with other conservatives at other law schools and do kind of Zoom conversations about some of these topics. If you don't have enough of you on your campus who are interested in having those types of discussions. So I think that you can seek out this kind of interaction, this kind of exposure to these viewpoints if you're not getting them where you currently are. And you can just reach out to faculty as well to help you assemble those readings or identify what you might want to get exposed to. And they should be willing to do that. I'm certainly willing to do that. If someone reached out to me and said, I really need some help figuring out what is the best originalist scholarship on this clause, I'd be happy to send them some recommendations.
Even podcast hosts help out from time to time when we get emails from law students.
Well, it's very easy now to find very thoughtful people who disagree with you and listen to them. I mean, one of my principles that I teach when I teach is I tell my students, as you get older, always seek out the best expression of the opposing side's point of view. That you should make that a priority. Like if you hear an idea that it sounds off or weird to you or you don't necessarily like it, go read the idea's proponent before you read the idea's opponent. Because then you're going to get the more full picture. Think about to the awkward moment at the start when I grew up as this very fundamentalist, small Southern Protestant. Well, they didn't even call themselves Protestants because Protestants were going to hell too. But a very, small, insular fundamentalist denomination.
Joel caught the two there.
Well, it was everybody but us. Just everybody but us. But anyway, the what I learned was, I learned a perspective from the standpoint of its alleged flaws. They didn't bring in a priest to talk to us about Catholicism. They didn't bring in, a Calvinist scholar from Reformed Theological Seminary to talk to us about Calvinism. Instead, they just presented the caricature. And that is the way so much discourse happens in this country is you learn about a new idea, and then you go read somebody who's ideologically aligned with you, and they'll tell you all the reasons why it's wrong. And this is plaguing us. So I think you have real capacity now to find information and to hear thoughtful voices that disagree with you. Just make it a priority to seek out the best expression of the opposing point of view. And it humanizes the opposition, sometimes points out weaknesses in your own understanding of the world. And even if at the end of the day, you still disagree with it and still think it's really bad, you're actually going to be much more effective in combating it because you understand it and not a caricature of it.
I find law review articles really hard to read. And I don't just mean like they're boring. They are that. And I do fall asleep. But also, I literally have trouble understanding them sometimes because you're so deep in the whatever academic world that they're in. They're really speaking to each other and not you. I love reading modern judicial opinions. And Judge, I wonder if you have sort of recommendations of how to find good opinions. Like, I think the Short Circuit newsletter is really good. It just like has little 1-paragraph summaries of circuit court decisions. And if one strikes you as interesting, like go jump in. But it's a good way to hear from a lot of different smart judges around the country and read their writing. It makes you a better writer, makes you a better thinker. They're engaging in real facts. To me, law review articles can be too theoretical for me to understand what they're talking about. How do you go about that?
Yeah, I mean, you mentioned Tom Goldstein. I am on How Appealing every day, and that will often flag most interesting, not only Supreme Court cases, but appellate cases. And that's a great way to find something that is relevant and, as you say, often really well written. I like the Originalism blog too. I think they'll often have scholarship in particular, but sometimes judicial opinions that are on really relevant topics. So I appreciate both of those. I think you're right. There's kind of this glut of information and being able to find good ways to shortcut advisory opinions. You all as well.
I was waiting.
You can take. You were waiting. But I got to say, you all flag a lot of the most interesting topics, most interesting cases that are percolating around the courts, and I know it's very helpful to a lot of us.
By the way, I was whacking law review articles not to whack academics, but rather if you're a law student and you're like, I'm not having a good time reading these and I don't understand them, I just want you to know, like, sames, you're good. Thank you so much for having us here. Thank you for the questions. Thank you for hosting us. This was a real treat. We talked about how much we have been wanting to talk about this subject. So all of it, the best. Thank you, Columbus Law School.